In the next race, we have Judge Brad, I don't know if it's Salmon or Salmon.
I pronounce the L, but I've been called worse.
Okay. And Judge Donna Stroud. Thank you. Thank you. In this race, Judge Salmon, with the L, will introduce himself first.
All right, good morning, everyone. It's very nice to be with you all, and it's nice to be in the Port City. My name's Brad Salmon. I'm currently a district court judge in District 11, which is Lee, Harnett, Johnston counties. My wife and I make our home in Sanford, North Carolina. I'd like to tell you a couple of foundational points about myself and my candidacy. First, I believe staunchly in the rule of law, and that partisan politics has no place in the fair and impartial meting out of justice. Our courts must be sacred institutions, as free as humanly possible from the stains of blatant political influence. Our independent judiciary, both in reality and public perspective, is imperative to our existence, to our existence in a free society. If elected, I pledge to uphold the autonomy of the courts and will do everything I can to keep politics from pervading our appellate courts. Second, I submit to you that I have a unique set of perspectives and experiences to be a Court of Appeals candidate. I was raised and am still active in the management of our multi-generation family farm in Harnett County. Cultivated in the tobacco fields and the church pews, hard work, sacrifice, and service became a way of life. After college and law school, I knew I wanted to return to my roots and give back. And there in Lillington, my sister-in-law and I founded a law firm. At the Salmon Law Firm, we took great pride in helping people and small businesses navigate their legal issues. In 2014, I was elected to the North Carolina General Assembly to represent Lee and Harnett counties. There, I was able to gain comprehension of the complex environment in which laws are made and see firsthand the impact on people, their impact on people and the institutions of our state. In 2021, I was honored to be supported by my peers and local and regional community leaders when I was appointed to the district court. My time in rural North Carolina as a farmer, a lawyer, along with having experience as a trial judge and a lawmaker, give me considerable perspective about the law and the people of our great state. I believe my temperament, balance, and collection of experiences would make me a valuable addition to our court. And I appreciate you being here. Thank you.
Judge Stroud.
Thank you. Good morning. I am Chief Judge Donna Stroud of the North Carolina Court of Appeals. I'm very honored to be here with you today. First time I joined you for one of these forums was in 2006 when I first ran for the Court of Appeals, and then in 2014 when I ran without opposition for re-election. So y'all do a great job on your forum, and I really appreciate you doing this. I was born and raised in Kinston, North Carolina, decided I wanted to be a lawyer in 3rd grade, not exactly sure why, but then went to Campbell University for undergraduate, finished that in 3 years, graduated in '88, then went to law school where I graduated first in my class. I wanted to go out and to be in a courtroom and deal with real people, so I went into private practice for 16 years. That was in Eastern Wake County, but I tried cases of all types all over the state, jury trials in many cases, including here in Wilmington. Did that, as I said, for 16 years, mostly civil litigation and family law. Also served as a Superior Court mediator and then a district court judge in Wake County in 2004. I've been serving as an adjunct professor teaching judicial process at Campbell Law School since 2008. And then, of course, when I was elected to the Court of Appeals in 2006, so I've been there for about 15 and a half years. Became chief judge in January of 2021. And of course, it's been a challenging time to be chief judge, just as your law firms have been going through the changes caused by remote work and COVID and all of the different things. We've been working with that at the Court of Appeals. Independence of the judiciary, the integrity of the courts at all levels has been one of the things I've been working on since I became a judge in many different ways. I don't have time to tell you about all of those. So I hope you'll look at the information. While I've been on the court, I have written over 1,200 opinions, participated in thousands of cases. So I ask you to judge me based upon my actual work that I've been doing for 18 years as a judge, for 34 years as an attorney. Thank you so much for having this forum, and I would appreciate your support in November. Thank you.
Okay, and now for the question for this race. Both our federal and state governments have three branches of government. Three branches: the executive, the judicial, and the legislative. Each branch has a distinctive role. When legislative matters are before the court, do you have a personal philosophy as to the degree of deference, if any, that should be given to laws enacted by the General Assembly? Please cite an example from your judicial career in which you've had to go along with a law that you did not agree with. Judge Salmon, you will go first.
Well, as I've stated, and I think as everyone stated, and we all know here, I mean, we as appellate judges are bound by the rule of law. The question is how much deference given to a law passed by the General Assembly before the court, I think goes through the same calculus. I guess there is some understanding that it is an elected body and that the opinion is, in a sense, the will of the people, but you're still bound by the precedent and whatever law that's already on the books as to the legality of the statute that was passed that's in front of you. So what was the second part of that question?
Please share with us an example where you've had to go along or follow a law that you did not agree with.
Well, you know, coming up through a law practice and now I guess sitting as a district court judge, you occasionally, you know, you sit and there's different circumstances where you're bound to rule in a certain, say, a criminal case based on a law that you may or may not agree with, but that is in fact the law on the books. And it's the same as I was speaking to the earlier part of the question. I mean, you're bound by the law that's before you, and that as a judge is something that should and must be taken seriously under our system of justice. So, thank you.
Judge Stroud?
Yes. Of course, in the thousands of cases that I've dealt with, there have been many times when we see statutes that that you don't necessarily agree with, or maybe the legislature just didn't think of some of the various things that can happen, and then we're confronted with a case that it's sort of a difficult fit. But if the language of a statute is clear, our job on the Court of Appeals is to follow that language. We are not to look to try to figure out the intent of the legislature, because something that I think is probably impossible to know in most instances. I'm sure most legislators maybe are not sure what their intent is sometimes when they pass many different laws. But of an example that I can think about, and there have been many different ones, but one that was just sort of interesting, and it was an issue actually arising out of a domestic violence protective order case, and there was a statute regarding the recording of proceedings. Of course, most proceedings in district court are not necessarily recorded, and so there was an issue. It's been a long time ago, so I might not have the details exactly right, but the bottom line was that there was the issue that was raised. This proceeding had not been recorded, and the party had raised an issue saying that this particular thing should have been recorded, and and therefore it should be reversed. And when we were looking at the actual statute, the statute that was there did in fact say that this particular thing should be recorded. Now, I know as a former district court judge that oftentimes those types of things were not recorded, depending upon the facilities available in a particular county. Sometimes it might not even be possible for them to do that. But the statute very clearly said that that had to be done, and so that is how we had to rule. And in fact, the legislature did change that statute, which I'm very glad they did, because I think it was something that was just overlooked and they had maybe not thought about. The District Court Judges Conference came up shortly after that, and I usually go to that conference. I didn't go that year because I had a conflict, but one of the judges was sort of joking with me and said, "Yeah, you didn't want to come because you knew everyone was mad at you about that ruling." And I was like, no. I mean, I knew you wouldn't be happy with that ruling because I know how things work in district court, but that is what the statute said, and that is what we had to do. And thank goodness the legislature fixed that one. They don't fix all the things we ask them to fix, but sometimes we do make some hints there. So, yes.
Thank you both.
All right, thank you.